Good morning, Officer Rosa. Are you with us? Hello?
Hello?
Hi, Officer Rosa.
Yes, how are you?
Great, how are you?
Good.
Perfect, so we're gonna get started. So I am Parole Officer Chisella. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Caron Johnson Christopher, inmate number 439729. Today's Tuesday, January 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record? I'm sorry, Mr. Johnson. Christopher, we're talking to you.
Oh, yeah, sorry.
That's okay.
Sorry.
Can you state your full name and DOC inmate number for the record, please?
439729.
Can you hear us?
Yeah, I can hear you now. Caron Johnson Christopher, 439729.
Thank you. Because it's a public hearing and public access to this hearing is available via video live stream. And present this morning is Attorney Sirica and Parole Officer Rosa. Attorney Sirica, can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit.
And Officer Rosa, can you please identify yourself for the record?
Yeah, Parole Officer Jamie Rosa.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings as to the findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. The testimony at today's hearing will be taken under oath. So Mr. Johnson Christopher and Officer Rosa, can you both please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. Then I'll review and identify exhibits filed for the record. The state will have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you'll have the same opportunity. After the consideration of all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have rights for this hearing, and we're going to review them now. The first right is you have the right to be represented by an attorney, and counsel is here present for you. You have the right to receive a written notice of the charges of violation. Did you receive the written notice?
Yes.
Great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. And at this hearing, you also have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. Officer Rosa, can you please read the violation details for charge number 1, condition of obedience to the law?
Yes, on 10/30/2024, you were arrested by Fairfield Police and charged with assault third and breach of peace second. Charges stem from domestic violence incident with the female victim. Victim reported to police that you were having a verbal argument and that you grabbed her by her shirt and struck her in the face, left cheek with a closed fist. Police observed minor redness to the victim's left cheek.
Thank you. The state has also filed the following exhibits that have been pre-marked for identification purposes. Officer Rosa, can you please read the evidence you've submitted?
Oh, I don't think I have that in front of me. I just printed the
I don't have a problem
violation.
if you're reading it.
Okay, all right, then I'm gonna go over them. So I have Exhibit A, parole conditions, Exhibit B, remand to custody, Exhibit C, the notice of parole violation, Exhibit D, the parole violation report, Exhibit E, the Fairfield police report, and Exhibit F, the Connecticut judicial branch pending case details. In addition, the state has also filed an addendum to the parole violation report on November 26, 2024. Officer Rosa, do you have the addendum to read?
Yes.
No? Okay, can you please read the addendum you submitted?
On 11/22/2024, offenders' criminal charges under docket F-028-CR24-035-9741/S were disposed. Offender pled guilty to assault third and was sentenced to 5 months jail. Concurrent with other cases, the charge of breach of peace second was nollied.
Thank you. Mr. Johnson Christopher, did you receive the notice of parole violation, the parole violation report, and all the other documents that have been marked for identification purposes?
Yes. Yes.
And were you able to review all of this information?
Yes.
In addition, I've received a list of exhibits from the defense. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, a basic high school diploma. Exhibit 3, a certificate of completion achievement of a hospitality operation technology, which is 4 pages. Exhibit 4, certification of completion of rage, advance, and stress management course. Exhibit 5, a certificate of completion for repairing the past, preparing the future in rage. Exhibit 6, a certificate of participation in smart recovery and poetry in motion. Exhibit 7 is a certificate of participation in goals group. See it, speak it, believe it. And Exhibit 8, certificate of achievement, which is credit awareness and motivation for life. Counsel, do you and your client need any additional time to submit other evidence?
No.
So say we have no witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to the evidence submitted. Officer Rosa, would you like to make any statements towards the charge?
No, I have nothing to add.
Yeah. And Attorney Sirica, it is now your opportunity to call any witnesses, present evidence, and speak to the charges.
Yeah, just briefly regarding the charge, I have no issues with the addendum that parole officer Rosa put on the record. That is the correct addendum regarding the disposition of the case on November 24th, where my client received a 5-month sentence. The only thing I do want to add, I know this is labeled as a domestic. There is a Fairfield Police Department case incident report, which its evidence is marked exhibit letter E. And on the 4th page, my client does speak to the police about the incident. He didn't flee. And his version of events was there was an incident, but it was not with the female victim. It was with the male victim who was with the domestic. As I indicated, he's charged. It's labeled as a domestic incident, and I just want you to know for the record that my client did speak to the police, and he did indicate to the police that his issue and the incident occurred with the male victim, not the female victim. That's my client's version of events. But as I indicated, I agree with P.O. Rosa regarding the disposition from court on November 22nd. That's all I have regarding the first part. I do want to be heard about my client's background at the appropriate time.
Okay, thank you. Before I announce my findings, I'm just going to take a moment. All right, so on charge number 1, I do find that you violated the condition of obedience to the law based on your conviction of assault third, when you were sentenced to 5 years in jail. In addition, the evidence provided to support the charge was Exhibit A, D, and E. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history, and after the state is finished, you will have the same opportunity. And the purpose of this part of the revocation is to help determine what outcome I'll recommend. So Officer Rosa, would you like to make a statement?
No, I have nothing to add that's not in the, in the PVR.
Okay, thank you. So counsel, it is now your opportunity to make a statement regarding your client's violation, background, and history.
Yes, on behalf of Mr. Johnson Christopher, my client, he's 26 years old. He does have one child. As indicated by the parole officer, there was no misconduct prior to this incident that occurred back in October. Upon his previous release, he was sponsored by his mother, Ms. Johnson. I did actually speak to his mother yesterday. She is still the viable sponsor for my client. And I provided you with her address and phone number in the document we submitted. She's also indicated to us he has a job lined up at the Connecticut in-home assistance, which is located in Stratford. His mother works there also, and I just spoke to her yesterday, so he does have a job available to him there. He did graduate from Basic High School, and you already did put on a record, so I'm not going to read these all again. But he's been in and out of the institution. He has made good use of his time, as you can see from all the certificates he's obtained. He did complete approximately half of the domestic violence classes, with the understanding once you miss 2 classes and you're removed either through a remand or don't finish, you have to start all over again. But he has started the Explore program. He, as I indicated, Ms. Johnson, her address in Bridgeport, phone number is listed in the document that I submitted. He does want to obtain his OSHA hours and reapply for the HVAC program at Port and Chester in Bridgeport. And as I indicated, he does have a job lined up with his mother. And that information is as recent as just yesterday. Karan, anything you want to add about your background or the plans for when you get out? And as I put on the record already, I actually personally spoke to your mother yesterday regarding she has a job lined up for you where she's employed and she wants to be your sponsor. Anything else you want to add?
No, I'm fine.
Okay, thank you.
Okay. I'll take a moment to review. I'll let you know my recommendation. So I have listened to the testimony today and I reviewed all the evidence provided. Based on that, I am going to recommend your parole be revoked and that you serve an approximate 1 year and 2 week period of confinement as a sanction with a no new re-parole date because your current sentence is November 14, 2025. So I'm going to present that to the board on January 16th. Yes, January 16th, 2025. And in the event they decide to lessen my sanction, I am going to recommend the following conditions: behavioral management program for domestic violence, no contact with your co-defendant James Estaba, no contact with your victim OF, a general no contact with TM, and a general no contact with LW or NP without your parole officer's permission. So those are my findings and recommendations. And like I said, I'm going to present them to the board on January 16th. And at that hearing, the board can lessen my recommended sanction or they can let it stand. That's all that can happen because they can't keep you longer, okay? Do you have any questions right now, Mr. Johnson, Christopher?
So that puts it at beyond the EOS?
Right now, that's your current EOS.
She matched it with your date, but it's going to the board. There's one other chance for them to review it on January 16th.
Yeah.
I thought my EOS was November 10th, 2025.
That is.
Okay.
Should be, I'll match up because you're earning time. Just hold on. That's what I have also, Karan. I have 11:10.
Oh, I have 11:10 too. So I'll change it. So with the no new referral date as your current end of sentence is November 10th, 2025. So yeah, so as your EOS, that's what it is. Okay. So as you keep earning the rec time.
And just wait till it goes to the board on the 16th and we'll see what happens.
All right.
Okay. All right. This concludes the final revocation hearing for Mr. Johnson Christopher, and I'm going off the record. You're all set, Mr. Johnson Christopher.
All right, thank you.
All right, I'll talk to you again, Karan. Let me see what happens at the board first.
All right,
Thank
thank
you.
you.
Yeah.
Bye.
Um, Hi, Kristen.
Yes.
Do we normally have issues connecting with York?
Sometimes,
Like
if they're,
Calling
I know that if
beneficial?
it's not the routine person, but I can give them a call and see if they have someone near the video room to answer.
Do you mind? And I'll try to connect with them one more time.
No, I'll reach out to them.
Awesome. Thank you. Hi. I don't think your camera's on. Is this York?
Yeah, I'm still waiting on the inmate.
Okay.
Are you looking for Campbell?
I am, yes.
Okay, let me see here. I'm trying to figure out how this works. I'm sorry.
I feel like, and she can correct me, is there a cam? Yeah, go ahead, Chris.
Yes, sorry, I was just on the phone. So if you look at the tablet, you'll see the icons where there's a camera icon, a microphone icon. So the camera should have a slash through it, and if you press that, it'll turn it on.
I don't have a tablet in front of me. Let's see here. What's this? Oh, hold on.
You use this funny words. It's just the screen that you can touch.
Yeah, the TV itself isn't touchscreen, but you should have a device right next to it or behind it.
Oh, there's
with the
there
buttons.
is, but I don't see. Is there like a? Oh. Yeah, I have a home. Is it like this little square thing? It has the home button and stuff on it.
When you say square thing, do you mean like it's 3 inches by 3 inches?
Yep.
So that's the computer itself.
Thank you.
Okay, it says Logitech on it.
Here.
But do you see an icon that looks like a little TV camera?
No, I see it. I just don't know how to click on it because I don't have a tablet in front of it. I don't know what this thing is, but do you know how to turn this thing on? I don't know. I've never done it. So this has a home screen. This doesn't do anything. I have a microphone. I have a
down
phone.
where the little video icon is.
No, I know that. I just don't know how to do it. Like, what do I touch? You know? That's what I'm saying.
It's not a touch screen.
It's a large computer, a large.
Well,
TV
there's like a
screen.
little screen thing, but it's not like turned on. There's no button on it to turn it on. I'm not sure.
If the screen's not turned on, if you tap the screen, it might just be sleeping.
Oh,
But if you
there's someone up here.
Yeah, but if you go to it, it won't click on it.
That's weird.
Right.
Oop.
Oh, let's see.
Oh,
Oh, you almost had it. There we go.
We did it.
Is it working now?
Yeah, we can see
Yes,
you.
we can see you.
us.
Okay, are you supposed to be able to see them?
I think so.
All right. No, I can't see you.
Can't see us?
Nope.
It just says Teams meeting and then the people.
There's no like join button like on the what's this thing?
well, you're already joined,
Yeah, it doesn't
so
have
there wouldn't be a button. But Is there a TV on display to see the meeting? And I don't know if the TV's turned on.
Oh yeah, I can see it shows like when we do the video visits, like it looks like the computer screen. It shows all the people that are in the meeting. It just doesn't have doesn't show you guys.
Okay, so if you do see everyone who's connected to the meeting, do you just see like a black box that maybe has like a circle icon with initials in it? Like maybe our video's not coming through? Usually like it would abbreviate like BOPP because it's a BOPP account.
I have DOC. All right, so let's see.
Because you might be seeing us, but might just not be getting the video.
Where do you live from? You from where? 0,
One more.
1 month.
Well, I can see you. Yeah, so your box is visible. See her. Yes, we'll just go forward so we can see her, right?
It's not. I don't know.
You're just muting everybody.
I know. I don't understand. It's not.
What's the little arrow next to the hang up thing?
So I mean, we're okay because unfortunately we can see you guys. As long as you're okay with moving forward without seeing us, we can just get going. Is that okay, Ms. Campbell?
Officer, you muted your end.
Oh, yeah.
No, can you ask the officer to come back in so she can touch the equipment, please?
I'll get in trouble. I promise. Oh.
Hello?
Hi, perfect. Thank you so much. All right, good morning, Ms. Campbell. How are you?
Good morning.
Good. So we are going to get started. I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Shauna Campbell, inmate number 420120. Today is Tuesday, January 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and York Correctional Center. Can you please state your full name and inmate number for the record?
Shauna Campbell, 420120.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. And present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Ms. Campbell.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates a condition of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. Also, the testimony at today's hearing would be taken or will be taken under oath. So, Ms. Campbell, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes, ma'am.
So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'm then going to review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you'll have the opportunity to address the issue of probable cause and the severity of the allegations. And at the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose of procedure before we begin?
No, ma'am.
Okay, so you do have important rights to this hearing, and I'm going to review them with you now. You have the right to an attorney, and counsel's present here for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case, and you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of legal obligation, the charging officer reported that as of 12/20/2024, when you were remanded back to York CI, you were not registered for DWOR, the Deadly Weapon Offender Registry. You were given the DWOR advisement March 2023 prior to being released on community release, September 2023 prior to re-release following top remand, and again December 2024 prior to discharge of special parole. To this day, you have yet to comply with the DWOR ordered by the court, as no active is documented in collect. During any review since March 2023, and the Connecticut State Police were also contacted and confirmed the inmate did not register. On charge number 2, condition of drugs, the charging officer reported that on December 19, 2024, on or about this date, you used cocaine and rendered a positive urine for cocaine and THC. Based on your actions, you were in violation of release direction, obey all laws. On charge number 3, condition of halfway house placement, the charging officer reported that on December 20th, 2024, you exhibited aggressive sexualized harassment behavior towards another inmate resident at Rise Halfway House. This violated the space of the other offender, and she reported feeling unsafe and uncomfortable. This is a violation of halfway house agreement number 7. I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On charge number 4, condition of mental health evaluation and treatment, the charging officer reported that as of 12/20/2024, you had not completed or made an attempt to schedule a mental health evaluation. Your failure to do so is a direct violation of your special parole additional conditions. The state has also filed the following exhibits pre-marked for identification purposes as Exhibit A, the signed statement of understanding and agreement of Connecticut conditions of special parole. Exhibit B, the Connecticut Board of Parole remand to custody order. Exhibit C, the notice of parole violation. Exhibit D, the parole violation report. Exhibit E, the notice of parolee rights. Exhibit F, the halfway house agreement. Exhibit G, the Rise Women's Program Residential Handbook. Exhibit H, the halfway house incident report from 12/19/2024 for notice of positive cocaine use. Exhibit I, the voluntary admission for positive test results from December 19, 2024, cocaine and THC use. Exhibit J, the halfway house incident report from 12/20/2024 for inappropriate sexual harassment towards another Rise resident. And I have modified Exhibit J. I also included the 2 written statements as Exhibit J. Counsel. I'll go back to this. So Exhibit K is the Board of Pardons and Paroles with written decision form from 8/18/2023 hearing date. Exhibit L is the text messages, 3 pages. So those 2 written statements.
I have a question regarding, that's fine, I have a copy.
Okay.
So the first one you have, I believe is my client with a signature with a date 12/20/24.
Yeah.
Statement number 2, do you see any date on there? Do you have a date on that statement? That's the one that begins with to whom it may concern, right?
Correct. I did not see a date.
There's no date on there, correct? Okay.
Okay, so those are the exhibits that the state has provided. I have not received any exhibits from the defense at this time. Is that correct?
That's correct.
Okay, do you need any time to submit?
No.
We have no witnesses today, so at this time it is the defense's opportunity to calling witnesses and testify with respect to probable cause.
Yes, regarding charge number 1 on the legal obligations, I'm asking that a no finding be made. I do not have, nor do I see any evidence that was presented by the state regarding that charge. It just indicated some point, and not even the exact date, it just gives a couple of months, not even a specific date of when she was advised regarding this registration. And I'm looking at exhibit A through L, or maybe one other one, because you added those documents. I don't see any evidence presented in support of the under legal obligation. So I'm asking that a no finding be made on charge number one. Charge number two, my client does admit to that. She was indicated to her that she would be placed in IOP because of the test, and obviously that occurred. She was remanded on that same date. Under charge number three, under halfway house placement, I'm also asking that a no finding be made on that. That charge deals with December 20th of 2024 is where the allegation is that my client exhibited aggressive sexualized harassment toward another inmate resident at Rise. Exhibit L is some text messages that go back and forth between my client and I'm gonna just put her, the other person's ES. I don't want to put her name on the record. And in reading these multiple times, I don't see anything here that's aggressive sexual harassment in these documents. It's my client and the other individual kind of going back and forth. On page 2, although there are no dates on there, I believe about halfway down, I'm not sure if yours looks a lot darker. I see Wednesday listed, and I'll give you a copy of mine. Yours is darker. So although it doesn't give a specific month and date, it does have Wednesday on there. You can clearly see that, I hope, correct?
Yeah.
Okay.
Okay.
And if I may have it back. So the reason why I'm asking that no finding be made. So my client is remanded at approximately that time. December 20th of 2024 is a Friday. I'm assuming this is from Wednesday the 18th, so 2 days prior to my client being remanded. This is the back and forth text and subject, obviously. I read this multiple times. It's kind of general conversation back and forth where the other individual is responding to my client questions and then kind of going back and forth. So I'm asking that a no finding be made on charge number 3. Charge number 4, I'm sorry, I don't believe you put Ms. Campbell. You did?
Yes.
All right. So Ms. Campbell, on charge number 4, the parole officer indicated that you didn't complete nor make any attempts to schedule a mental health evaluation. Can you please let the hearing examiner know what attempts, if any, you made and how it went about for your mental health evaluation?
When I got to Women Rise, Officer Sheehan told me that she was recommending that I go to Ford Clinic in New Haven for mental health because they do one-on-one, they do medications, they do groups. And within a day or two, I attempted to call them to schedule an appointment and the number was disconnected. I made mention of this to my case manager, Ikeda Gibson, and she said that she would look into it for me and get back to me. I didn't know that there was a timestamp on it. Otherwise, I would have sought other ways of going about it. But I did make multiple calls to Ford Clinic and the number was disconnected.
And that number being disconnected is, you just testified in what you previously told me. You brought that matter up to the case manager and what was her name?
Ikeda Gibson.
Ikeda Gibson, and you told her you were having difficulties scheduling your mental health evaluation.
Yes, she said on her next day off, she would go down to the Ford Clinic because multiple people were having an issue getting in contact with them, and she would go down there and find out what was going on with their phone.
Okay, thank you. Those are my comments regarding these charges. I know this is a preliminary hearing where probable cause has to be established. Then the second prong is it serious enough that my client should be held pending a revocation hearing? And I am submitting to you these, if you were even to make findings on all 4 of these, this does not rise to the level where my client should be incarcerated. Number 1, once again, charge number 1 on the legal obligation, the state has presented 0 evidence to back up that charge. Number 2 is an admission, is dirty urine. Charge number 3, once again, under the halfway house placement, that text messages in no way, shape or form is indicated any hostility between my client, and ES. And on charge number 4, my client, their testimony, she did make an attempt. The number was disconnected. She did bring it to her, case manager's attention. It's not like she didn't just blew it off and didn't do anything. She made more than one attempt, to schedule that appointment. Thank you.
Thank you. So I'm just gonna take a moment and I'll let you know my findings. So I'm gonna announce my findings. So I'm gonna make a no finding of probable cause for charge number 1, condition of legal obligation, as the state did fail to submit sufficient evidence in support of the charge. I am going to make a finding of probable cause on charge number 2, condition of drugs, based on state's exhibit A, D, H, and I. I'm also going to make a finding of probable cause for charge number 3 for halfway house placement, based on state's exhibit A, D, F, G, and J. And I'm going to make a no finding of probable cause on charge number 4, condition of mental health evaluation and treatment as deemed necessary, as again, I feel like the state failed to submit sufficient evidence in support of the charge. So those are the findings that I'm making today, and I am going to find that the acts are serious enough to warrant revocation. So I've determined that you'll remain detained while you wait your revocation hearing, and the records department and your parole officer will be notified. At your revocation hearing, Ms. Campbell, myself or another hearing examiner will determine if you violated the conditions of your parole, and if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and if any sanctions should be imposed. Do you have any questions right now, Ms. Campbell?
No, ma'am.
Then you're all set, and this does conclude the preliminary hearing, and I'm going to the record.
Shauna, I'll set up another call with you once I get the revocation date. As I indicated to you, it has to be within 60 business days. So once I get the date, I'll set up another call with you. And as I also indicated to you, my social worker will reach out to you about your background, okay?
All right, thank you.
All right.
Thank you. This concludes the preliminary hearing for Shauna Campbell. All right, you're all set, Ms. Campbell. Take care.
Thank you.
Hey, Roscoe?
I think my other ones. When I was working. Kristen,
Yes.
any thoughts on Corrigan?
Well,
Just
let me
how-
try to dial them from my end, but they show available. It's possible someone's just not there to hear the call.
All right, so I'll try calling the facility.
Yeah, we can try calling the facility and just see if there's an officer there.
All right, great. Thank you. Hello. Oh, we can hear you too. Good morning.
Good morning.
Can you see us?
I can see you, yep.
Awesome.
All right. Who you guys see?
Junior Ramos.
Okay, perfect, yep. I'll give him a call, have him come down.
Okay, thank you.
You're welcome. Yeah. Those people.
I'm just trying to see, but that's what it. They absolutely model and actually downstairs on the first.
Yeah, rest of us, that's great. Yeah, really.
I can understand. But the only thing with that. So we have.
You're all out here, depending on if the phone back up.
Well, they all are.
Yeah. And call.
It's like.
Yeah. Yeah, no, this is just
Good morning, Mr. Ramos. How are you?
Good, how are you?
Good. So we're going to get started. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Junior Ramos, inmate number 390150. Today is January 7, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Corrigan Correctional Center. Can you please state your full name and inmate number for the record?
Junior Javier Ramos, 390150.
This is a public hearing and public access to this hearing is available via video live stream. And present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean from the Parole Revocation Unit of the Public Defender's Office on behalf of Junior Ramos. Good morning, sir.
Good, how are you?
Good morning, good.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegation by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to the panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Ramos, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for the hearing. So first, I'm going to read you your rights. We'll then review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that they have filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights to this hearing, and I'm going to review them with you now. You have the right to be represented by an attorney, and counsel's here present for you. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, I did.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case, and you have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
We're going to review the charges that the state, your parole officer, is bringing against you and the underlying information of each charge. So for charge number 1, condition of obedience to the law, the charging officer reported that on August 29, 2024, you were taken into custody for an active warrant issued by the Connecticut State Police for an incident that occurred on or about February 27, 2024. The warrant is charging you with Connecticut General Statute 53A-151A, intimidating a witness, in an ongoing case out of the Willimantic Superior Court. According to the report, you confronted victim 1 in the warrant and discussed the ongoing case, in which you were reported saying, "He better not press charges against my friend, and if he did, you would find him and things would escalate." Due to your actions and that active warrant, you are in violation of your parole condition section 2, obey all laws, and subsection A, obedience to the law of criminal. The state has filed the following exhibits that have been pre-marked for identification purposes, which are Exhibit A, the signed statement of understanding and agreement condition of parole. Exhibit B, the remand to custody order. Exhibit C, the violation notice of parole violation. Exhibit D, the parole violation report. And Exhibit E, the Connecticut State Police warrant number 2400125-250. In addition, the state has filed an addendum to the parole violation report on December 11, 2024, and that's also admitted into evidence and reads as follows. On December 10, 2024, Junior Ramos was seen at GA21 in Norwich regarding docket number K21NCR24-0171194, coercion threats of felony for an incident that occurred on February 27, 2024. Junior Ramos pled guilty to this charge and was sentenced to 1 year jail, execution suspended after 4 months, conditional discharge of 3 months. Mr. Ramos, did you receive the notice of parole violation, the parole violation report, and all the other documents that have been marked for identification purposes?
Yes, I did.
Great. And I also received an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and plans for future parole reinstatement. Is that accurate, Attorney Dean?
Yes,
And do you and your client need any additional time to submit other evidence?
we do not, thank you.
So we do not have any witnesses today, so it is the defense's opportunity to now call any witnesses, present evidence, and speak to the charges of any of the evidence submitted.
Thank you. Just very briefly, no comments as to the preponderance standard, but I do just want to note that is accurate. The addendum, my client did resolve this matter on 12/10/24. It was an Alford plea to 1 count of the witness coercion. As you stated accurately, it's 1 year suspended after the service of 4 months, 3 years of the conditional discharge, 3 months of conditional discharge. And my client's max date has passed as of 12/27/24. So that sentence is finished, the actual time to serve portion of that sentence. In addition, as was noted, this is an incident that occurred the alleged incident occurred almost a year ago. It was on 2/27/24. And I would add the appropriate time asked to speak to his down and future plans.
Thank you. Just gonna take a moment, I'll announce my findings. Right, so for charge number 1, I do find that you violated the condition of obedience to the law based on your conviction of coercion threat of a felony on December 10th, 2024, when you were sentenced to the 1-year jail, execution suspended after 4 months, followed by the 3 months of conditional discharge. In addition, the following exhibits support the charge, which is Exhibit A, D, and E. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, you and your attorney will have the opportunity to speak to your background and history. Attorney Dean, would you like to make a statement?
Yes, thank you very much. Mr. Ramos is 36 years old, born in Little Manson, Connecticut, raised in Lebanon, Connecticut. He has a very large family network of support in Connecticut, including his mom, dad, brother, sister, aunt, and various extended family members. One of his favorite hobbies is playing billiards. He plays in a league and receives support from that community, in addition to the support of a few close friends as well. He is a veteran. He served 8 years in the U.S. Army before he received an honorable discharge in 2013. Most recently, while on special parole, he was self-sponsored at an address in Taftville, Connecticut. Previously, he successfully completed the Connections Eddie Center. He was also sponsored by his parents at some point in Lebanon, Connecticut, until he got his own apartment, and thereafter was self-sponsored at that address in Taftville. He previously successfully completed the mechanics program at Porter and Chester in 2019. Beginning in November 2023, he reportedly enrolled in the tractor trailer training program NETS in Somers, Connecticut, and to earn his CDL. He reportedly completed the classwork portion and was about to start the driving portion of the program. He was employed full-time as a lube technician at Uppisville Quick Lube. He previously worked as a mechanic for Northwest Towing Transport in Norwich, was full-time at another mechanic shop in Preston, and then also had a full-time position at Atlantic City Supply Network in Norwich as well. He also previously worked full-time at Donovan Marine. He reports being 7 years sober. He does attend 12-step AA meetings, Narcotics Anonymous meetings as well. He goes about once or twice a month. He does do therapy and medication management. That's through the VA in Norwich. He successfully completed the Connections CTP-SB program. And while on supervision, he was doing a number of positive things to give back to his community. He reports that he was organizing a charity pool event in support of Veterans Park in Enfield, Connecticut, and then was also organizing a charity suicide awareness pool tournament that would have been held in February. He was on a minimum contact schedule, doing very well. He also successfully completed requirements as far as the registry are required. Upon his reinstatement to parole, he would like to be sponsored by his parents, Marcelina and Miguel in Lebanon, Connecticut. Ultimately, he would like to obtain independent housing. His last landlord he's going to work with to see if he has an apartment available for him that he will look into if so permitted. In the near future, he's hoping to continue his education by completing the driver portion of the tractor trailer training school to try and get his CDL type A. He is also looking forward to returning to that full-time position that he had at Uppisville Quick Lube and is hoping he can return there. He also intends to engage in any sort of required treatment. He wants to re-engage with the clinical services he was receiving at the VA, both for mental health and his primary care, and then also wants to get back to the 12-step meetings. My client has been incarcerated on this matter since August 29th of last year, so nearly 5 months at this point. I would ask for the soonest possible release date for him, and that the sting should not exceed what he received arraigned in court, as that penalty has already been served, the actual time to serve portion. And my client was doing a number of really positive things while he was in the community, and I know he is hoping to get back to that. Thank you very much for your time and consideration.
Thank you. Just gonna take a moment. I'll let you know my recommendation. Okay. So I have reviewed all the evidence and I listened to the testimony today. And based on that, I am going to recommend that your parole be revoked and that you serve an approximate 5-month period of confinement as a sanction with the reparole date of January 29th, 2025. In addition, I'm going to recommend the following conditions: no alcoholic beverages, no contact with victim SR, general no contact with DS, no contact with minors, mental health treatment, problem sexual behavior treatment. And you said your parents were your sponsor, correct?
Yes,
So no
ma'am.
halfway house?
No.
So those are my recommendations, and they're going to be forwarded to the board on January 16th. And on that date, you'll receive the written notice after that date. So on that date, the board can't really lessen my well, they can, because there's 2 weeks in between. So they can lessen my recommendation on that date. They can have my recommendation stand, or they can impose a sanction longer than what I've recommended. If they do choose to impose a sanction longer than what I've recommended, a supplemental hearing will be held, and you will be notified of that supplemental hearing and the reasons why and what they want to address with you, because you'll be present for it to answer their questions. Okay.
Yes,
Do you have
ma'am.
any questions right now, Mr. Ramos?
Not really questions, just I feel this is a little ridiculous that this happened back in February. It wasn't exactly what they said. I did confront the individual for putting his hands on a female who
Mr. Ramos, I just wouldn't say anything related to the actual charges here. What I can do is, if you want to call my office on the 16th, which is the board review date, we can let you know what they decide. And if for any reason they expand the sanction, then we will be entitled to another hearing that we can discuss together, okay? Thank you very much.
This includes the revocation hearing for Gina Ramos. I'm going off the record. Okay, you're all set, Mr. Ramos.
Yep.
Have a good day.
You too.
Hello.
Hi, how are you?
Great. How are you?
Good.
I'm just here for Mr. Raymond.
Oh, okay, I have him here.
Awesome. Thank you.
You're welcome. Come on in, Raymond.
Good morning, Mr. Raymond. How are you?
Good morning. All right.
Good. So I can't start until exactly 10:30. So we have about 4 minutes. Okay. So I'll be right with
Okay.
you in 4 minutes. Awesome. Thank you.
No problem.
Is it Rear Baker? Okay, I just want to make sure they understand Roger at 10:45, 7. Okay, okay. It's in my 10:45. I just want to make sure you remember. Which one? I bet. No, you just say my 10:45. Okay.
Okay, good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning William Raymond, inmate number 2355540. Today is Tuesday, January 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
William Patrick Raymond, 235540.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. We're going to go over the purpose of today's hearing. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you, and the state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be held to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Raymond, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify the exhibits that they have filed for the record. The state is not present at today's hearing. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights for this hearing, so we're going to go over them now. You have a right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that you can have an attorney to represent you at this hearing?
Yes.
Okay, and do you intend to hire your own attorney or seek counsel for this hearing? So just one more time to confirm, you're okay with going forward today without legal representation? Yes. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes.
You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're going to review the charges that the state your parole officer is bringing against you and the underlying information for each charge. So on charge number 1, condition of reporting, the charging officer reported that on 8/23/24, offender failed to report to the New Haven District Office or CPA halfway house as directed. Charge number 2, condition of program participation, the charging officer reported that on 9/12/2024, offender was unsuccessfully discharged from the Ford Clinic substance abuse program due to failing to attend scheduled sessions. For charge number 3, condition of residence, the charging officer reported that on 8/20/2024, AWOL sober house manager Daryl reported offender failed to return home since 8/15/2024 and was unable to get in contact with him. Daryl reported he spoke to offender today and advised him to report to Redemption House Recovery Transition Placement due to failing to report home. Offender refused to go. As a result, Daryl expressed offender cannot return to the program. For charge number 4, condition of absconder, the charging officer reported that on 8/23/24, offender failed to report to New Haven District Office or CPA halfway house as directed after being discharged from sober house on 8/20/2024. On charge number 5, condition of obedience to law, the charging officer reported that on 10/5/2024, you were arrested by Bristol PD for interfering and issued a summons. And on charge number 6, condition of drugs, the charging officer reported that on July 2nd, 2024, offender voluntarily admitted to abusing cocaine and signed a voluntary admission. Offender tested positive for cocaine on 7/8/2024 and positive for fentanyl on 8/9/2024 at the Ford Clinic. On 7/29/24, offender rendered a urine in the district office, which yielded positive results for cocaine. The state has also filed the following exhibits that have been pre-marked for identification purposes. As Exhibit A, the Connecticut Conditions of Parole. Exhibit B, the Connecticut Board of Parole Remand to Custody Order. Exhibit C, the Notice of Parole Violation. Exhibit D, the Parole Violation Report. Exhibit E, the Voluntary Admission. Exhibit F, the Premier Lab Results from 7/29/24. Exhibit G, the Unsigned Misconducts. Exhibit H, the Ford Clinical Progress Report and Unsuccessful Discharge Summary. Exhibit I, the Bristol Police Department Summons ME 005862. That is all. In addition, the state has filed 2 addendums to the parole violation report. The first was on October 10th, 2024, and states in reference to the parole violation report submitted by P.O. Smith regarding William Raymond, number 235540, the following applies. On September 25th, 2024, the Board of Parole issued a warrant based on that report declaring the offender an absconder from special parole supervision. On 10/1/24, the case was transferred to the FIU for investigation. On 10/5/24, Raymond was arrested by Bristol Police Department and charged with interfering and issued a misdemeanor summons. A remand to custody was lodged with Bristol Police Department, and Raymond was served his parole violation notice on 10/9/2024 and signed notice of parole violation. Parole rights and remands were scanned into case notes on 10/10/2024. The second addendum submitted by the state was submitted on December 9th, 2024, and states on December 6th, 2024, on docket number H15N CR 24035139-S. Raymond did not enter a plea for interfering and received a nollie. On docket number H15N motor vehicle 24-0451406S, Raymond did not enter a plea for failure to insure a private motor vehicle and operating an unregistered motor vehicle and received a nollie. Those were both admitted into evidence as well. So, Mr. Raymond, did you receive the notice of parole violation, the parole violation reports, and all the other documents I have marked for identification purposes?
Yes, I did.
I have not received any exhibits from you. Is that correct? Any evidence?
Yes, no.
You need more time to submit any evidence?
No.
Okay. So we do not have any witnesses. So at this time, it is your opportunity to respond to the parole violation charges against you. However, remember that you can remain silent if you choose to do so. So at this time, would you like to make a statement, call any witnesses, or testify regarding your case?
No, ma'am.
So we're just gonna jump into the findings of your charges. So for charge number 1, I find that you violated the condition of reporting based on the evidence presented in Exhibit A and D. On charge number 2, I find that you violated the condition of program participation based on Exhibit A, D, and H. Charge number 3, I find that you violated the condition of residence based on Exhibit A and D. On charge number 4, I find that you violated the condition of absconder based on Exhibit A and D. On charge number 5, condition of obedience to the law, I'm making a no finding as the state failed to provide evidence in support of the charge. And for charge number 6, I actually separated it into 4 separate parts for each date they charged you. So for the 2 parts that are dated July 8th, 2024 and August 9th, 2024, I'm making a no finding as the state failed to submit sufficient evidence in support of the charge. And for the other 2 dates of July 2nd, 2024 and July 29th, 2024, I am finding that you violated the condition of drugs based on the evidence in Exhibit A, D, E, and F. So that does conclude my fact-finding portion of the hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history, and this will help determine the outcome of the recommendation. So at this time, would you like to make a statement regarding the violation, background, and or history?
I would just like to say, yes, I did admit to the urine originally, which I was dirty, and I was working full time. I was living at the house. I was doing very well, and an incident occurred where I didn't come home on time, and I handled the situation wrong by not calling in, and when I should have just called and said I'm going to be late or whatever, but I didn't, and he didn't. To my knowledge, he didn't ask me to come back to the house. He told me I couldn't. So I reported to the officer. He told me to report to the halfway house. I did not because I was working a very good job and we only had like 2 weeks left and I was getting paid cash and it was good money for the landscape. And so I was like, I was just going to try to get the money together so I can just get my own place, which I handled that wrong. I admit to those and I can't take those back, but after the original dirty urine I did while I attended meetings, like I got myself off methadone. I've been clean off heroin for 3 years. The dirty urine for fentanyl had to have been because of the coke. I did not attend the Ford clinic at them because that happened when he did send me to go to the halfway house. I was already told not to come back. So there was, to that point, no reporting back to New Haven for the clinic. But, you know, I made some mistakes, but, you know, like I said, I've been off heroin for 3 years, or fentanyl, what you like to call it. I successfully got myself off methadone. I was working full time. I was doing well. Like I said, I made some mistakes and those things I can take back, but I did not go on and commit any new crimes. I wasn't, you know, in that kind of behavior or mindset. And the motor vehicle, which say dropped, which I showed evidence to the court that at the time, the motor vehicle was still supposed to be registered through the previous owner. I was paying them to keep it registered. I waited for the title. So I believe that's why they ended up denying it, because I didn't know it was unregistered at the time. So that is a whole nother story. But from my step while I was at the house, like I admitted to them and I was going to Ford Clinic on my own, trying to do the right thing. And, you know, I did make some mistakes. So for that, I'm just, either way, I'm still proud in the way I handled most of the situation. I didn't bring it out of control. You know, there's nothing I could do about it but go forward. And that's what I'm trying to do.
Thank you. Just to get some clarification, you mentioned that you started going to meetings after your first dirty urine. You're talking AA meetings, or was it like
the house? Yeah, the house, we had AA meetings. I reported in the community all the time. I was going to the Ford Clinic after work at time, but when he said I didn't finish the report, that happened as when he told me to report to the halfway house and I didn't. So I did not keep going at that point. Yes.
Okay. So at that moment when you stopped didn't go back to halfway house, you were not attending treatment or meetings?
Yes, but I wasn't using though.
Okay.
I wasn't going. I was working all the time. I was just trying to get my finances in order so I could try to, because I asked him, I was like, can we find another house? I paid $2,000 to get moved into that house, you know? And he's like, no, you got to go back to Havas. You know, he kept bringing up the dirty urine. I thought that was a little unfair. I said, I am working. I'm trying to do the right thing. And I just, you know, I felt a little upset about that. And the overall situation I handled wrong. I should have reported or whatever, but I didn't. You know, I didn't go about making it worse. That's one thing I can say for myself. Like normally that's what I used to fall back on, but you know, I am trying.
Thank you. I'm just gonna take a moment, then I'll let you know my recommendation, okay? All right. So I have listened to your testimony today and I have reviewed all of the evidence submitted. Based on that, I am going to recommend that your parole be revoked and that you serve an approximate 5-month period of confinement with a re-parole date of March 5th, 2025. In addition to that recommendation, I'm going to recommend the following conditions. No alcohol consumption, no contact with the co-defendant Diane Brandy, a general no contact with TD Bank, 826 Wolcott Road in Wolcott, and general no contact with Lowe's, 3270 Berlin Turnpike, Newington, mental health evaluation. Do you have a sponsor, Mr. Raymond, or will you need a halfway house?
Halfway house. I have a question about the mental health, why they keep bringing, I haven't been on mental health medication in many years. And I was discharged off that from the facility successfully. So they brought that up out there. I did attend in groups because they asked me to. I just don't understand why that's there. When I initially discharged from the DOC in 2020 started, I was no longer on any kind of medication or seeking mental health treatment.
Okay, so
I would like
it is from a previous stipulation added. So what I can recommend is that when you get out, work with your parole officer, see what they recommend, because they can request us to remove it. But at this time, I don't know any of the grounds behind why they have requested it.
I was just curious about that. It is
evaluation and treatment as deemed necessary. So if you go out, when you go out again and they send you for an evaluation, it could also be up to whoever that clinician is if they don't feel it treatment's necessary, okay? But work with them to either remove it or just get the evaluation done and whatever's recommended, okay? You said halfway house, correct?
Yes.
What area?
Hartford.
Hartford. So my recommendation is going to go to the board on January 16th. On that date, the board can either accept my recommendation, they can lower it if they choose to do so, or they can increase it if they want to. You'll receive a written notice within a week of that hearing date on January 16th. And if for any reason they do choose to do a sanction longer than what I've recommended, you will be notified of the hearing, why they want to extend it and what they want to discuss with you, because there will be a supplemental hearing that you'll be present for to address their concerns before it happens, okay? Do you have any questions for me right now, Mr. Raymond?
No.
All right, so you are all set. I do appreciate you talking to me today. And this does conclude your revocation hearing.
All right, thank you. You have a good day now.
Take care, Mr. Raymond. Good luck with everything.
Thank you.
Word. You ready talking?
What's that?
Already.
Bye, thank you.
All right, you're welcome. Have a good one.
You too.
Thank you.
Time that I saw the dermatologist virtually.
Hello, good morning.
Good morning.
All right, we're gonna get started in 1 minute, Mr. Altman, okay?
Yes, miss.
Thank you. Hi, Attorney Joe.
Good morning.
Good morning.
Good morning, Mr. Altman. Good morning, P.O. Babich.
Good morning.
Yes.
Good morning.
And then you're seen by someone the next day, right? Yeah.
Okay, good morning. I'm Parole Officer Casella, and I'm a hearing examiner at the Board of Pardons and Paroles. This is a revocation hearing concerning Ryan Altman, inmate number 409524. Today is Tuesday, January 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office at MacDougall Correctional Institution. Can you please state your full name and inmate number for the record?
Ryan Altman, 409524.
And that's when.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Jones and Parole Officer Babich. Is it Babich? Babich. Can you please identify yourself for the record, Attorney Jones?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Altman.
And Officer Babich, can you please identify yourself for the record? Officer Babich, Montgomery Residential. Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegation by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. And the testimony at today's hearing will be taken under oath. So Mr. Altman and Officer Babich, can you both please raise your right hands?
I believe that I wrote her again.
You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God upon penalty of perjury.
I wasn't letting up.
Christmas.
I wasn't letting
Perfect.
up.
So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we'll review the parole violation charges that the state, your parole officer, is bringing against you. We will then review and identify the exhibits for the record. The state will then have the opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. If I find that you have violated one or more of the conditions of your parole, the state will have the opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
I do. One question.
Okay.
On the original thing, which we went through already, which was, I believe, what that was the whole preliminary process, was to determine you specifically had found the residence was no finding.
Right. So Ryan, they won't address those today. We won't
No.
address
Yeah,
anything there was a no finding on. It won't be addressed for today's
Then
purposes.
she went and added. Now she just changed the wording of it to halfway house placement. Now before there was 5, now there's 6. So residence is removed because there was no finding, but she just reworded it to halfway house placement and added all the same exact things, but just called it something different.
No, that's
Halfway
always,
house.
unless I'm mistaken, I did not receive any additional parole violation reports. So that is something that was always in existence. Am I correct?
Look, I have right here is five charges, and then now here there's 6 charges.
No.
So I've always had the halfway house as well.
And I have always had it as well. I have 6 charges, Ryan, and I've always had 6 charges, and we defended 6 charges at the preliminary hearing.
No way. I have all the original paperwork and there's 5. 100%. I mean, I have all the paperwork.
Yeah, I don't,
Here's the original, look, here's the original thing right here. Look, charge 1 to charge 5. On this, I mean, it's from Blue, Connecticut, 10/16 to 12 p.m.
That's under, I have that.
Oh, no, you're right, hold on. There is halfway house placement. It's charge 1 GPS, charge.
So Mr. Altman, can we go
Yeah, I'm sorry.
start heading through it, and then if you find the discrepancies, like, flag us,
Honestly,
wave us, stop us?
I'm not trying to be a weirdo with all that. I just noticed that just while sitting here. But I also, I just wanted to say that it feels like almost maybe like you guys are going through all this paperwork that I feel you already went through, we went through. I have no discrepancy that I was asked, you know, say, what, a technical violation, technically for sure violated a lot of the things here.
So listen, Ryan, listen, at your preliminary hearing, we went through everything. We went through all 6 of the charges.
I don't even want to argue it though. I don't want to argue with them.
Listen.
I just want to say, look, I'm sorry.
Okay, but
give me a chance. You know what
we're
I'm
gonna
saying?
do that.
Gosh, like, come on, man.
And I'm gonna do that.
All this paperwork, it's just ridiculous.
I have a few comments. Yeah, I have a few comments to make though on the charges. But let's go through the process, make my comments, and then we're going to move forward to the second portion where I think that's where you'd like to be heard and say your apologies, and that would be the appropriate time. But we have to go through the process, okay? Okay, thank you.
Okay. So yes, all right. So we do have to just go over your rights for the hearing. You have the right to be represented by an attorney, and counsel is here present to represent you. You have the right to receive the written notice of the charges violations. It sounds like you received it because you held it up and I saw you looking through it. You also have the right to review the evidence against you, and you have the right to submit evidence in support of your case, and you have the right to call and examine voluntary witnesses and adverse witnesses. Mr. Altman, do you understand all these rights, and are you still ready to go forward?
Can I ask one question? Yeah. I just want to say about the witnesses thing. Initially, I had written this whole list of all these people. Are they available today?
I'm not aware of any witnesses, Ryan, but your witnesses also have to be relevant to defenses on each of these charges.
Well, it was like all the people from the halfway house that made all these ridiculous claims, like saying I was going to dismember somebody, like Toya. That's a complete lie. So is she here to really like raise her hand on oath and say that she swears that I said that? Because that's ridiculous.
She isn't here to do that, but would you like a continuance so that these people can be
it's just
called?
like if she's gonna get the credibility on this paperwork to be able to, you guys gonna take that under like say that you believe that.
Mr. Altman, as your attorney explained, are they relevant? Are they going to support the
violation? I mean, it's just like if that's even
cause to the violation.
Do you really believe that, miss?
Okay. All right.
Listen,
so,
like if you're going to take that as word and say you believe that and want to charge me for it, then I want her to actually come on video and say that I said that, because that's freaking ridiculous.
Attorney Jones,
Ryan, you have a couple of options here. We can go forward and defend your charges, or we can request a continuance if you would like to explore any the possibility of calling any of the witnesses.
I mean, realistically, I just want
to.
I'm sorry.
Right now, I'm not even.
So Attorney Jones, you would call all the witnesses for your client, correct?
I'm sorry.
So I don't know, Mr. Altman, I'm sorry, I didn't hear what your decision was.
Yeah, I'm not sure. Ryan, do you want to go forward?
I mean, I'm just gonna go with God here, man, and say like, I believe in God, and realistically, this is.
So it's.
I mean, I'm a good person, you know what I mean? I didn't say that. Look at it realistically.
Right, so Ryan, do you want to go forward?
Look at me. Do I seem like I even speak like that?
Ryan, do you want to go forward with the hearing today, or would you like a continuance for any purpose?
I do. I have faith in this lady and Mrs. Babich to have realistic, you know what I mean?
Okay, so you would like to go forward?
Yeah, I want to say.
Okay. so let them,
No,
okay,
come
so
on.
let them
You
read.
know I'm a
let-
good dude. This is
Okay,
great.
so let the parole officer read the charges, okay? And so, so we can go forward, okay?
There's just a procedure we have to follow, Mr. Altman. You'll have your opportunity towards the end of the hearing for the stuff. So we are going to review the charges now. Officer Babich, can you please review them? You can exclude charge 3 as residence was found within, there was a no finding found, so that one does not need to be considered today, and it is not considered today. And there's also the 2 parts in 13, yeah, to have them.
Okay, so I don't read the no finding ones.
Yeah.
I believe this
GPS battery is shut down from 11:15 p.m. on 9/28/24 until 11:29 a.m. on 9/29/24 for 12 hours and 13 minutes. This is a violation of your GPS monitoring agreement. States I am responsible for the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Your GPS battery is shut down from 2:15 p.m. on 9/29 until 2:29 p.m. on 9/29 for 16 minutes. This is a violation of your GPS monitoring agreement, which states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Your GPS battery is shut down from 5:51 a.m. until 10:08 a.m. on 10/2 for 4 hours and 17 minutes. This is a violation of your GPS monitoring agreement, which states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging outlet for at least 2 hours each day. Your GPS battery is shut down from 1:27 p.m. until 2:11 p.m. on 10/2 for 40 minutes. The violation of your GPS monitoring agreement, which states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Your GPS battery is shut down from 7:12 a.m. until 8:28 a.m. on 10/7/24 for an hour and 15 minutes. This is a violation of your GPS monitoring agreement, which states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Your GPS battery is shut down from 12 a.m. or 1 p.m. on 10/9/24 for 15 hours and 29 minutes. This is a violation of your GPS monitoring agreement, which states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Your GPS battery is shut down from 6:28 a.m. until 8:07 a.m. on 10/10/24 for an hour and 38 minutes. This is a violation of your GPS monitoring agreement, which states I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Do I keep going through everything?
Oh, yeah, charge 2.
Charge 2, program participation, 8/30/24. You were unsuccessfully discharged from Renato, where you were attending your BOP stipulated mental health treatment after making, quote, aggressive and threatening comments to your clinician. You've been banned from their facility. Charge 4, obedience to the law. On 10/10/24, it was reported by halfway house maintenance staff that your bedroom window and the window in the hallway near your roof broken, and that you had admitted to him that you had broken the spring. Based on your actions, you are guilty of criminal mischief and a warrant is pending for your arrest on the charge at this time. Charge 5, halfway house placement. On 8/18/24, you were observed on halfway house surveillance cameras handing data determined to another offender resident. This is a violation of your halfway house agreement, which states I have read and understand and agree to comply with the program during my period of residence in a DOC halfway house. Page 18 of the client handbook states that possession, introduction, or use of any narcotic, paraphernalia, or not prescribed. On 8/30/24, you were observed by Renato staff getting into the passenger side of your girlfriend's car and driving away from the program. You did not have prior written approval from the role to be in the vehicle. This is a violation of your halfway house agreement. It states I will not operate a vehicle, nor will I be a passenger in the vehicle without prior written approval from the role. On 8/31/24, during a pat search of your person by halfway house staff, you were found to be in possession of smokable marijuana in the halfway house. This is a violation of your halfway house agreement, which states I will not consume or possess alcohol or marijuana in the halfway house. On
24, you requested permission from halfway house staff for a drop off. The request was denied due to not being previously approved by the program director. Your girlfriend came onto the property anyway, and you failed to obey staff direction to go inside and not approach her. This is a violation of the halfway house agreement, which states, I have read, understand, and agree to comply with the program rules during my period of residence in the DOC halfway house. Page 16 of the client handbook states, clients are prohibited to have unauthorized visitors on property. Page 18 of the client handbook states, conduct which disrupts or interferes with the security or running of the facility is a prohibited act. On 9/9/24, you were observed leaving the kitchen with cereal hidden under your shirt. When staff stopped you, you threw the cereal to avoid detection. Staff asked you why you stole the food from the kitchen. You denied stealing the cereal, claiming that you were just hungry. This is a violation of your halfway house agreement, which states, I have read, understand, and agree to comply with the program rules during my period of residence in a DOC halfway house. Page 16 of the client handbook states no food is allowed outside of the dining area without staff permission. And page 18 states that stealing is a prohibited act. On 9/16/24, you were found in possession of a marijuana vape pen and valve. This is a violation of your halfway house agreement, which states I will not possess vape pens inside the halfway house. On 10/4/24, you told halfway house staff that you're going to quote dismember your roommate if quote nothing was done. Staff spoke to your roommate who stated that he'd asked you to throw away food, quote, stashing in the closet. This is a violation of your halfway house agreement, which states, I will treat others with respect and not engage in physical relations with vendors, staff, and third parties. And I have read, understand, and agree to comply with the during my period of residence in the DOC halfway house. Page 15 of the handbook states no food is allowed out in the dining area without staff permission. And page 18 states spreading another bodily harm is a prohibited act. On 10/4/24, when a staff member couldn't really locate your cutting knife, or need to find my fucking knife, I'm not playing with you. I'm tired of playing these games with all of you. You were asked to lower your tone after the knife was found. To this, you replied, quote, fuck you, I'm tired of playing fucking games with you. This is a violation of your halfway house agreement, which states I will treat others with respect and not engage in physical or verbal or physical altercation with other offenders, staff, or third parties. On 10/7/24, you called the halfway house job developer a quote pussy, and he could not speak with you at the time due to conducting a facility head count. This is a violation of your halfway house agreement, which states I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On 10/8/24, you yelled at your parole officer, quote, you're a scumbag and a liar. You're a scumbag and do nothing but lie, and you're a lying scumbag. This is a violation of your halfway house agreement, which states I will treat others with respect and not engage in verbal or physical altercations with offenders, staff, or third parties. On 10/10/24, you called the halfway house kitchen faggot and quote pussy and several other residents. This is a violation of your halfway house agreement, which states I will treat others with respect and not engage in other offenders, staff, or parties. Charge 6, mental health treatment. On 8/30/24, you were unsuccessfully discharged from Renato, where you were attending your BOPP stipulated mental health treatment after making quote aggressive and threatening comments to your and you can the facility.
Thank you. Evidence was submitted and identified at the preliminary hearing, and those all do remain the same. There was new evidence submitted that I'm going to mark as, it was just a disciplinary report, so those are now identified as State's Exhibit 00. Also, the state did file an addendum to the, or multiple addendums to the violations. Officer Babich, can you please read the 3 addendums that you have submitted?
Don't believe I have them printed out.
Okay.
Sorry, and it's Exhibit O, all 8 of the DRs?
I did lump.
They're all, okay, so they're all 8 and all.
Yes, all 8.
I'm sorry, I did not print out the
I
addendum.
do have this. Do you want to read off of it? Or sure.
Some type of resolution.
So the first one you submitted on October 22nd, 2024, correct?
10, 11, 10, 12, 4. Altman received 2 Class A disciplinary reports. One was for threats and the other was for flagrant disobedience. On 10/15/24, he received a Class A disciplinary report for interfering with safety and security. The 3 PRs have been attached under violation evidence and case of review. Addendum 2, on 10/26/24, Altman received a Class A fighting. On 10/30/24, he received a Class A disciplinary report for interfering with safety or security. For administrative jargon 9.2, offender prosecution, rejected classification manual.
Even though it wasn't working, they wouldn't give me that no more either. So it came a point in time where they were giving me absolute
12/24 through 10/24 in the interest of progressive discipline. He is now an overall level 4 offender housed in MacDougall Walker. The 2 DRs have been attached under parole violation evidence in case 2. And addendum number 3, on 11/15/24, Altman received 3 Class A disciplinary reports. 2 were for threats and the 3rd using house. The 3 DRs have been attached under parole violation evidence in case of review.
Yes.
Yeah.
Thank you.
Attorney Jones, did you and your client receive the notice of parole violation, the parole violation reports, and all of the documents that have been identified?
Yes.
I'm saying she engaged in.
I also did receive an exhibit from the defense, and that's exhibit 1, which is a list of parole accomplishments and future plans for statement. Do you and your client need any time to submit any additional evidence?
I don't believe so.
Mr. Altman, are you ready to move forward?
As a result of her.
Yes.
Okay, so today we do not have witnesses, so it is now the state's opportunity to call any witnesses, present evidence, and speak to the evidence submitted. Officer Babich, do you have any statements you'd like to make?
Just that I would like to reiterate my initial 6-month recommendation. Not only were there a number of charges in the community, but 8 Class A DRs that received.
And now it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges. Attorney Jones?
Yes, thank you. As you know, we did have a preliminary hearing in this matter. I'm going to reiterate some of my comments to the charges as the standard of proof is now different. In regards to charge 1 under GPS, again, I would just note that Exhibit FF, my client was issued a misconduct given a verbal warning, but also refused to sign because he maintained he was having issues with the charger, and a new charger was issued to him. And then again, for the second portion, he did experience issues with his GPS monitoring device, and that he requested a new device and was given a new device. In regards
I wasn't given a new device. From the second day when I went to work at
a new charger
in the freezer. Yeah, but something was the matter with that device. Every time I would go to work,
I'm sorry, I misspoke. Ryan, I misspoke. I meant to say that you requested a new charger and were given a new charger.
I requested a new device.
Okay.
And was given a new charger. Ms. Babich was very aware of the fact that I requested a new device. That was actually why, and I apologize, and I do not think it's okay that I called her a scumbag. I'm sorry, Ms. Babich. That was what triggered me and why I started getting all weird and called her a scumbag, because I asked for her new device. She said she would help me the next day, never came the next day. Then I saw her like 5 days later at the halfway house. I said, Ms. Babich, she said something, I'll be tomorrow. She brought a charger then the next day. And then when I said, Miss, I didn't ask for a new charger. I'm saying that there's something the matter with the device. The thing, every time I go in the freezer at work, the thing starts vibrating, going all crazy. You're saying that you want me to sign this misconduct. It's the device, there's something the matter with it. Then she says, but it was on a foot where I had shattered my heel and it was hurting me, physically hurting me. I said, I asked her also, can you please put it on the left leg? So there's something wrong with it. I need a new device, but I also need it put on the other leg. She said, well, you can skate to the halfway house tomorrow if you want. Now it's already been 2 weeks. She's trying to have me sign a misconduct for like I'm doing something wrong with the thing when 2 weeks prior I had told her it was hurting me and I need it put on the left leg. She says you can skate over. I couldn't skate anywhere. My foot hurt so bad at that point I could barely walk. I had gone to the CVS and bought special ankle braces to pad the thing because it hurt so bad. So she said it like sarcastically. Well, you can skate over if you want. When at this point I couldn't barely walk with the thing. So I was asking her to come to the halfway house or do something, help me put it on the left leg and put a properly working one on the left leg. And she there's no way she could raise her hand on oath right now and say that she doesn't know that that's exactly what happened.
Okay. All right. Thank you, Ryan, for
Do you
those.
dispute that? Do you
Ryan,
dispute that? I
Ryan.
asked you to put it on the left leg.
Ryan,
Can, but I have to, Attorney Jones, Officer Babich wants to respond, but do you want to finish your part first?
No, I want to have my specific questions to her would
But
be.
you don't, I don't
Okay.
need to. Keep going. It's fine.
Ryan, it's okay. Relax, okay?
Yeah.
Thank you. I would just ask P.O. Babich, if you recall the situation where Mr. Altman did request a new device, and that you gave him a new charger instead of replacing his device.
Well, first of all, I just want to say that I checked his points regularly. The GPS unit was functioning fine. The issue was the charging, which was why I gave him a new charger. I went in every day, every couple of days. The unit was not malfunctioning. I mean, the offenders do get the alerts, you know, for batteries and unable to connect. And he did have a number of unable to connect the freezer at FHI, but the unit was not improperly working.
Okay, thank you.
How come every time I would go into
Ryan.
the freezer at work, the thing would get hot?
So
and start
P.O.
vibrating?
Babich, if I may ask you, were any of your violations directly related to the conduct where he was entering the freezer and the device was malfunctioning in the freezer?
No, they're all due to battery shutdowns.
Okay, thank you. In regards to charge 2 under program participation, I would just point out that my client had completed an IOP and on, I believe it was July 15th of 24, and was attending the Renata Treatment Center only on a voluntary basis, and he was there on that particular day to give a urine, and that's what my client has relayed to me. In regards to charge 4 under obedience to the law, I would just point out that the charge is indicating that my client is guilty of criminal mischief. It's not indicating a statute number, a subsection of the statute. It's basing that information on a warrant that it's pending for his arrest. And I would just point out again that my investigator has checked since the date of remand when it was indicated to us that there was a pending warrant for my client's arrest. And we are unable to confirm that there is in fact any pending warrant for his arrest for the charge of criminal mischief in any degree. And so therefore we would submit there's insufficient evidence to support that charge. I don't believe there's any evidence entered here that would support that. And again, we were unable to verify that. In fact, we were told there was no warrant. Thank you in regards to that charge. And then in regards to charge 5, halfway house placement, addressing the first portion of that charge, the August 18th of 24 paragraph, I would just point out that rolling papers are not paraphernalia unless they're associated with a controlled substance. And in that particular subsection, there's no indication that my client had any sort of controlled substance on his person that he was intending to use rolling papers for. In regards to the paragraph beginning August 31st of 24, where it's indicating that there was a pat down of my client and he was found to be in possession of smokable marijuana. Again, my client denies that. There's no indication that the substance was ever tested. So we don't know. In fact,
there was never even.
Okay, Ryan, let me finish speaking, please. So there's no indication that there was any substance that was tested and that in fact it tested positive for THC or marijuana. In regards to the 9/2/24 paragraph.
He was a pat down, he had marijuana. What are you talking about? Is there video? Is there actual marijuana? It never even happened. It never happened.
Okay,
Well,
I'm
Ryan,
gonna have to, you have to let your attorney speak because we have to get through this. You have to let her get through what she's trying to do, okay?
Sorry, I was like, she's saying it. It's like, it's just making me think. I'm like, this is crazy. Like, these people just write stuff on paper and then you guys like want to, like, you Miss Babich, I mean, sorry for any rude thing said, but you are like a total neutral party, Miss. And I'm like, wow, this is crazy. This lady's being presented this like evidence. It's not even evidence. It's like never even happened. It's just a bunch of lies from the staff at the halfway house.
Okay, so addressing the paragraph on September 9th of 24, my client maintains that he arrived back to the halfway house from work, he missed breakfast, and that the kitchen staff did in fact give him permission to take food, that he was not in fact stealing any food. In Exhibit Z, he was issued and served a sanction where he was restricted in his community passes, was given extra chores. So we point those things out. On the 9/16/24, my client denies using marijuana in the halfway house. He was in possession of a battery for a vape pen and not a vape pen.
That's true.
And again, exhibit BB, he states he did not use marijuana at the halfway house. In regards to, I just have a minute.
The cereal thing is true. You know,
In
like
regards
some
to
of
the
it's true.
In regards to the paragraph, October 4th of 24, that addresses my client's knife that he used for work. Again, it's a knife that he uses for work. The halfway house took possession of the knife, and then they apparently lost the knife. He works at Bizzuto's in Cheshire. He needed that for his employment.
At this point,
He was issued a sanction and restricted community passes that were served in regards to that conduct. In regards to, I believe, in regards to the charge 6 mental health treatment, again, my same comments for program participation. My client maintains that he was at that program on a voluntary basis, having successfully completed the IOP. No further comments as to the charges.
Thank you.
exactly.
Thank you.
Okay, so I'm just gonna take a moment and then I'll review. Are you all set? You did want to make a comment? No additional comments? Okay. Let you know my finding.
Like if anyone looking at my scalp can see what was going on with it. This was a problem. It wasn't just about going to see a dermatologist. It was about getting some type of medical treatment. At that point, they were giving me none.
It's at MacDougall. They're on the opposite side of the wall. Yes, I might as well just ask. I have a question. Officer Babich, was Mr. Altman at Renato voluntarily?
He had a mental health evaluation and treatment as deemed necessary, STIP, I believe.
Okay.
So, you would just be at mental health treatment for mental health, including monitoring. So he had the mental health treatment stipulation. So, they stepped him down to individual sessions after the completion of IOP, which is their recommended protocol.
Got it. Okay. Great, thank you. So I am going to make my findings now. So on charge number 1, I do find that you violated the condition of GPS based on states exhibit A, B, and X, double D, double E, and double F. On charge number 2, I find that you violated the condition of program participation based on states exhibit A, N, O, double M, and double N. On charge number 4, condition of obedience to the law, I make a no finding as I don't believe the state submitted sufficient evidence in support of the charge. On charge number 5, I find that you violated the condition of halfway house placement based on exhibit A, B, F, L, M, P, Q, R, T, V, W, Y, B, double G, double H, double K, double L, and double M. So that does conclude the fact-finding portion of the hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history, and after the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. Officer Babich, would you like to make a statement?
That's as the way you're speaking it just seems.
And counsel, do you wish to make a statement regarding your client's violation, background, and history?
Yes, thank you. My client is 40 years of age. He's a high school graduate. He did complete some college. He has support in the community by way of his mother, father, siblings, as well as his significant other. He has been in custody now for approximately 3 months. He was in the community for approximately 4 months, and I believe this is to be his first violation of his parole. During the time that he was in the community, he utilized the Connecticut Renaissance Halfway House in Waterbury. He also was able to obtain employment working at Green Meadows Landscaping, as well as Bizzuto's in Cheshire. My client was also receiving treatment at Connecticut Counseling Center in Waterbury and received medication-assisted treatment in the form of methadone. In addition, he received treatment at McCall Behavioral Health, Renato Network in Waterbury, where he successfully completed the intensive outpatient program there. He also was participating in the Explorer program. It indicates that he completed 12 of 26 classes in that programming. If he's re-paroled, he would like to be sponsored by his significant other. Her name is Chantel Benoit, and her information is contained within Defense Exhibit 1. As a secondary option, he's asking for placement in a halfway house in the Waterbury area. He would like, when he re-enters the community, he's interested in continuing his education and would like to complete a veterinarian technician program. He also indicates that he's eligible to return to his full-time position at Bizzuto's in Cheshire. And lastly, my client is agreeable to all treatment recommendations of his parole officer. And I would just ask, I believe that there was some indication that P.O. Babich was requesting that there be a mental health examination to determine a higher level of care or needs of my client. And I'm not certain if that was ever done and if the recommendation is that he be supervised by the mental health unit. Based on my communications, that certainly seems appropriate to me, but obviously I'm not a medical provider and I don't know. So I'm not sure if P.O. Babich has some information and some light to shed on that issue. But we would be asking that he be re-paroled at the next available date, noting that he has been incarcerated now for approximately 3 months.
Thank you. And Mr. Altman, I know you've been waiting patiently to speak. Would you like to make any statements at this time?
I just want to say, sorry for being so jumpy in the beginning. I really do have terrible anxiety and PTSD. The whole probation and parole all started from my wife threatening to kill my kid.
It's her discretion.
I'm not a violent person at all. I was simply responded with a text message. I said, if you harm one hair on his head, I'll kill you. If I could go back 10 years ago and take that back, I would. That was 10 years ago. This parole, the probation part of it got violated with a charge impersonation of a police officer. I've never been to that town. That charge was thrown out. So technically, the 4-year sentence is an illegal sentence that should, I have habeas paperwork to try to like get that all resolved. I understand that that's not Mrs. Babich's job or your job at this point, and that's like irrelevant to, you know what I mean, where we're at today with this. But I mean, I've served time in jail that I shouldn't have served to then be let out, and I understand that I was on, you know what I mean? It's like I needed to be polite. I needed to follow all the rules. But I mean, I've already been wrongfully persecuted here. Can you please just allow me the chance to get back to my life? I have two kids that are counting on me. You know, I just missed Christmas with them. I'm not a bad dude. I'm just a little bit traumatized from everything that's happened. And definitely handled it poorly. Like, Ms. Babich, I'm sorry for being rude to you. You know, I had bad issues with my mom. You remind me of my mom. You're definitely on drugs. And my mom was on drugs. I mean, there's no way you're going to tell me you're not on drugs.
Mr. Altman, you need to learn how to control your thoughts sometimes.
Like, my mom was a drug addict. I dealt with it my whole life.
Right.
So you're going to tell me she doesn't do drugs.
I'm going to move forward now with the recommendation because I was listening to your story and what you're going to do, and this is about you and nobody else, but you don't know how to keep your focus.
Right. But no, what I'm saying is that's where I get.
Okay, so Ryan, in one sense, you're apologizing for your conduct, but in the next sense, you're kind of saying some rude and inconsiderate things. So
what do you mean to say she's on drugs? That's like she's
that's
a medical fact.
That's not a fact. Ryan, that's obviously a rude comment. Okay, so just
what do you mean it's a rude comment? This is facts. This is not a rude. I'm not saying.
Okay, well, so now I'm going to.
I'm saying that's why I get angry with her because she is on drugs. Is why I call her a scumbag. It's not okay to call her a scumbag, but she is definitely on drugs.
Mr. Altman,
I'm not saying it to be rude.
I'm going to move forward now. I believe that you can control your your thoughts and your comments.
I'm not saying that to be rude.
We're not going to mute you.
I just want to clarify that. I'm not saying that to be rude to her.
It doesn't matter. I'm done. We're moving forward. So at this time, I have listened to testimony. I did review all the evidence submitted. And I am going to recommend that your parole be revoked and that you serve an approximate 6 month period of confinement as a sanction with a re-parole date of April 10th, 2025. And I'm going to recommend the following conditions: no alcohol beverage consumption, behavioral management program for domestic violence, no contact with the victim LC, mental health treatment, And I am going to submit your sponsor, but I'm going to do a halfway house just in case if anything happens.
Oh,
So
can I
my
say one thing, Liz?
recommendation-
Can I
No,
just
I'm gonna
clarify?
finish.
I apologize. Was the date April 10th?
April 10th, yes,
Okay.
2025,
Okay.
6 months. So I'm
And
going
the-
to finish first. So my findings will go to the board on January 16th, 2025. And at that date afterwards, you'll receive a written notice from them. At that hearing, the board can either lessen my recommended sanction, they can adopt my recommended sanction, or they can impose a sanction longer than what I've recommended. If that does happen, you'll be notified because a supplemental hearing will be held and you'll be present for it to address their concerns and to discuss why they believe that it should be a longer sanction than what I've recommended.
Can I ask one
Attorney
question?
Jones.
May I inquire of P.O. Babich, whether or not we do know if he will be supervised following his release and reparole to this mental health unit?
That's what my witness list was.
To be evaluated since being incarcerated. I was trying to get him evaluated at HCC and then he got moved to Osborn and then at Osborn.
I got evaluated here. I got
Okay.
evaluated at every place I've been. I talked to the mental health here. They said that what they did here is 100% a formal evaluation so for her to
Okay,
say,
so do we know
for
the results
anybody to
of the
say,
evaluation or no?
I'm sorry, I couldn't hear what?
I signed
So on my-
releases for
on
all.
my end, Attorney Jones, I'm going to, when I do the dispo, we're able to put the different units.
will. Okay,
So I'm
thank you,
going to
thank
do
you.
mental health unit. It'll be up to
All right.
PCS at the time of his release to, I think they might do it. I'm not sure how it works, but I'm going to recommend the
All right,
unit.
perfect. Thank you. I appreciate it.
They are going to need the evaluation
They
to
can,
review.
well, you guys,
Okay.
I'll do my end to say that this is what's gonna be, when I do the dispo on whatever happens, whatever the date is, whatever he's given, I will just put it in the disposition. It'll be up to
Yeah,
DOC.
no way I could work with Mrs. Babich again and be successful. I mean, it's a trigger.
Okay, so maybe things will be different, and I just hope you continue to work on yourself, okay, Mr. Altman? This does
Thank you,
conclude
Miss.
your
I appreciate it. I'm
revocation
not trying, I'm
hearing.
not like, I didn't mean that to be an attack. It's facts. Look at her.
Well, maybe just take
All
a
right,
breath before you say
Ryan.
stuff, all right? So you're all set.
Good luck. If you have
Wait,
any
you got
questions, you can.
drugs. Look at her. You're sitting right next to her.
It's okay.
Ryan,
We're
if you have any
done.
questions after the January 16th board review, please give me a call, okay? If you want to know whether or not the board accepted the recommendation, okay?
Well, you were saying, okay, so one more thing though. I have two sponsors and addresses.
Okay. So what you could do
I
is you
only
could write
was
the
able to provide
second
you
one.
with one. What is it,
Okay, would
Miss?
you like to provide the second sponsor right now on the record?
I don't, it's, her name is Mrs. Munko.
Do you have her address and phone number?
Honestly, if you look at it, I'm sure you could go backtrack. It's one of the things you guys tried to use against me. The
No, but
text
Ryan, do you have
messages.
the information right now? If you don't have the information right now, then you can get it to, I believe the discharge planner at DOC is somebody that might maybe
You can
help
get
with
the
the community.
information, yeah, write it on a correspondence to the IPO in the facility and they'll forward it to me, okay?
Yes, ma'am.
But for
All right,
now,
good
I'll
luck, Ryan.
submit
Thank
the-
you.
You're all set. Take care.
Thank
This
you.
concludes
Sorry
the
for,
revocation for Ryan Altman.
That's me.
You're all set.
Thank you.
Take care,
Good luck,
Mr.
Ryan.
Bye, Attorney Jones. Thank you.
Thank you. Thank you, Tio Babich.
Howard, you know you do drugs.
Oh, hello.
Hi, good morning.
Oh, good morning. I'm sorry. Oh, we're behind. We're behind
No, that's
now.
okay. Do you want me to log off?
No,
and log
you
back on?
stay. You are perfect, Officer Richardson. I just need 5 seconds to just get my thoughts together and then call the facility, okay?
I mean, you're better than me. I would need like 5 minutes after. You take all the time you need. Hi,
This
Jamie.
This hearing was a doozy. We all need to recover from it.
Yeah, seriously.
Just be careful. We're on live. Stop.
How you doing? Are you here to speak to Zelensky?
We're here for Mr. Quinton Neal.
Okay, hold on.
Thank you.
Officer Trustello, was Neal moved to Hartford or are they at Cybulski?
I called the wrong facility. Oh, CO. Who'd I call?
Sorry, I meant, yeah, New Haven, not Hartford.
Shoot, should I just hang up? Is that rude?
I can take care of it.
What do you need? You got this?
In your defense,
Officer Richardson.
I'm not trained.
Cybulski won't answer, and I have called them and they said that they're there. So I'm gonna keep trying for like 2 more minutes.
Sure, no problem.
And then the plan is, I will jump to my other hearing because I have one at 12:15 while our media tech tries to get in touch with them. And get you back on eventually. Does that work? I know you guys are busy.
No, it's okay. Yeah. Just let me know. Like, do you want me to just hang out here while you try again, or do you?
If you don't mind, just
No,
know
not at all.
for any reason it is live stream. So if you want to mute yourself, it might. I don't know where you are, what's going on. Just so you don't all hear everything.
I'll definitely mute. I'll just stay logged in then, so I don't miss it.
Perfect. Thank you.
No, thank you.
There is a microphone icon. Good afternoon. Are you Mr. Elliott?
Yes.
Okay, Mr. Elliott, so we're gonna start, but I can't start until 12:15, so in 2 minutes we'll start, okay?
All right.
All right, cool. I'll be right back with you. Okay. Good afternoon, I'm Parole Officer Trisella, and I'm a hearing examiner at the Board of Pardons and Paroles. This is a preliminary hearing concerning Antonio Elliott, inmate number 389191. Today is Tuesday, January 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Hartford Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Antonio Elliott, inmate number 389191.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. This is a preliminary hearing, which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. And the testimony at today's hearing will be taken under oath. So, Mr. Elliott, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning the case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for your hearing. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have the opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I'll inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights to this hearing, and the first right that you have is that you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney can represent you at this hearing?
Yes.
Okay, and are you intending to seek counsel for this hearing?
No.
So just to confirm, you are okay with moving forward today without any legal representation?
Yes.
You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
You also have the right to review evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine any voluntary witnesses or cross-examine any adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes. I didn't get the evidence, but yes.
You did not get the evidence?
No.
Would you
I
like
just got the charges.
Okay, so no, so you haven't received a packet of the evidence. Would you like to continue this hearing to receive that evidence?
Will
My
I
next
still,
hearing, date is January 21st.
Will I still get it even after the hearing?
So if we stop now and continue this for you to receive it, we'll make sure that we get a copy of it to you before your next hearing date.
Nah, I'll just go with it.
Okay, as long as you're sure. So I am gonna review the charges now that the parole officer has brought against you. It just is gonna take me a moment to get through, so bear with me. But I'm gonna read each of the charges and the underlying violation details. So for charge number 1, condition of GPS, your charging officer reported that on 12/5/24, you were issued a misconduct for battery shutdowns to your GPS unit on the following dates: 11/6/24 from 2:14 a.m. to 8:40 a.m., 11/7/24 from 4:55 a.m. to 7:45 a.m., 11/17/24 from 11:20 a.m. to 11:25 a.m., and 11/25/24 from 7:04 p.m. to 11/26/24 at 12:50 a.m. You're in violation of your signed GPS monitoring agreement. On charge number 2, condition of obedience to the law, the charging officer reported that on 12/16/24, during a motor vehicle stop in the city of New Britain, officers of the New Britain PD conducted a canine search of the vehicle you were operating. During the search, officers confiscated a Smith & Wesson .380 caliber firearm containing 6 rounds in its magazine, 1 plastic bag containing crack cocaine, and 8 purple vials containing crack cocaine. Both bags and vials have an aggregate weight totaling 10.59 grams. During the motor vehicle stop, it was also determined that you were operating the vehicle with a suspended driver's license. Subsequently, you were arrested for the following charges: 21A-278B1A, possession with intent narcotic substance; 14-18A, failure to display plates, inserts; 14-215, illegal operation of a motor vehicle under suspension; 53A-212, stealing firearm; 53A-217, criminal possession of a firearm, ammo, defense weapons; 21A-279A2, possession of controlled substance, second offense; 29-38, legal possession of a weapon in motor vehicle. And you were arraigned in New Britain Superior Court on 12/17/2024 for the charges previously specified. On charge number 3, condition of drugs, the charging officer reported that on 12/16/24, during a motor vehicle stop in the city of New Britain, officers of the New Britain PD conducted a canine search of the vehicle you were operating. During the search, officers confiscated 1 plastic bag containing crack cocaine and 8 purple vials containing crack cocaine. Both bag and vials have an aggregate weight totaling 10.59 grams. Subsequently, you were arrested for the following charges: 21A-278B1A, possession with intent narcotic substance; 21A-279A2, possession of controlled substance, second offense. You were arraigned in New Britain Superior Court on 12/17/24 for the charges previously specified. On charge number 4, condition of weapons, the charging officer reported that on 12/16/24, during a motor vehicle stop in the city of New Britain, officers of the New Britain PD conducted a canine search of the vehicle you were operating. During the search, officers confiscated a Smith & Wesson .380 caliber firearm containing 6 rounds in its magazine, registered to another party. Subsequently, you were arrested for the following charges: 53A-212, stealing a firearm; 53A-217, criminal possession of a firearm, ammo, defense weapon; 29-38, illegal possession of a weapon in a motor vehicle. And you were arraigned in New Britain Superior Court on 12/17/2024 for the charges previously specified. Charge number 5, statutory release criteria. On 12/16/24, during a motor vehicle stop in the city of New Britain, officers of the New Britain PD conducted a canine search of the vehicle you were operating. During the search, officers confiscated a Smith & Wesson .380 caliber firearm containing 6 rounds in its magazine, 1 plastic bag containing crack cocaine, 8 purple vials containing crack cocaine. Both bag and vials have an aggravated weight totaling 10.59 grams. During the motor vehicle stop, it was also determined that you were operating the vehicle with a suspended driver's license. Subsequently, you were arrested for the following charges: 21A-278B1A, possession with intent narcotic substance; 14-18A, failure to display plates, inserts; 14-215, illegal operation of a motor vehicle under suspension; 53A-212, stealing a firearm; 53A-217, criminal possession of a firearm and defense weapon; 21A-279A, 2, possession controlled substance, second offense; 29-38, illegal possession of a weapon in a motor vehicle. You were arraigned in Britain Superior Court on 12/17/2024 for the charges previously specified. The state has also submitted the following exhibits that have been pre-marked for identification purposes. That's Exhibit A, which was the remand to custody. Exhibit B, the parole violation notice. Exhibit C, the parole violation report. Exhibit D, the signed parole conditions. Exhibit E, the signed GPS agreement. Exhibit F, the New Britain police reports. Exhibit G, the misconduct report dated 12/5/24. Exhibit H, the decision information summary. Exhibit I, the Connecticut judicial case lookup. And Exhibit J, the Allied Universal GPS monitoring reports. So we already discussed this, but you mentioned that you did not receive any of the evidence I've just identified. Is that correct?
Yes, I haven't received it.
Okay, so one more time, would you like to continue this hearing for you to receive the evidence, or are you still willing to move forward?
No, I'm willing to move forward.
Okay. So I have not received any exhibits from you. So at this time, it is now your opportunity to respond to the parole violation charges against you. However, I do want you to remember that you have the right to remain silent if you choose to do so. And that anything said at this hearing can be used against you, okay? So would you like to make a statement regarding the charges of your violation?
Yeah, I know that the GPS violations, I know that I violated those. One was while I was at work, I couldn't leave work to charge it. And the other two, I fell asleep getting off of work and didn't wake up and charge it. But as for the charges, I wasn't operating the vehicle. But
So I just want to, again, you're pending a court case, correct? This is still pending in court. So just so you're aware, anything you say today can be used against you at any point. So I just want to remind you, you do have the right to remain silent as well, okay? So
I'm just wondering if the case gets dropped, if the criminal case gets dropped, what will be the next, like what will happen next?
So whenever the disposition happens of that case, whatever happens, we'll be notified by your parole officer and you'll come back for a revocation. We'll meet again to go over the thing. But as of now, again, if it is still pending, just know that this is an adversarial proceeding as well, okay?
No, I know.
All right, would you like to, make any other statements or just for the GPS?
No, will I be able to still just get the evidence against me, even though I'm doing the hearing right now?
Yeah, I'll make note of it and I'll tell my supervisor. It should be on its way if you haven't received it yet, because sometimes they put it in the mail. But I will make note of it.
All right.
Okay, so we're ready to move forward then?
Yeah, I know I'm guilty. Yeah.
Okay. Okay. Anyway, so I'm going to make my findings. So for charge number 1, a condition of GPS, I do make a finding of probable cause based on the state's exhibit C, D, E, G, and J. Charge number 2, I make a finding of probable cause for obedience to the law based on exhibit C, D, F, and I. Charge number 3, condition of drugs, I make a finding based on state's probable cause based on state's exhibit C, D, and F. And charge number 4, condition of weapons, I'm making a finding of probable cause for state's exhibits C, D, and F. On charge number 5, the condition of statutory release criteria, I'm making a no finding of probable cause as the violation doesn't meet, the violation meets the elements of other Connecticut parole conditions, and therefore the state didn't provide sufficient evidence in support of that charge. So at this time, I am making a finding that the acts are also serious enough to warrant revocation, and I've also determined you should be detained while you wait your revocation hearing. So the records office and your parole officer will be notified of this information. As we just discussed, revocation hearing will be scheduled upon the disposition of your pending criminal charges, okay? So once that happens, we'll get you back here, okay? Do you have any questions at this point, Mr. Elliott?
No.
Okay, we are all set then, and I have made note that if for any reason you don't receive the evidence, you can write to your institutional parole officer and ask them for them, but I would assume that it's probably coming to you in the next week or so, okay?
All right.
All right, so this does conclude the preliminary hearings for Antonio Elliott, and we are going off the record. You're all set, Mr. Elliott.
Thank you.
Have a good day.
You too. Mhm.
Mr. Neal?
Hello?
You are Mr. Neal. Perfect. We're gonna get started, okay, Mr. Neal?
Yeah.
Oh, sorry, I totally forgot about you, Officer Richardson.
No, that's okay.
I'm glad you're here. Okay.
No worries. Hi, Mr. Neal.
Hello?
All right. So good afternoon. I'm Parole Officer Trissell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Quinton Neal, inmate number 300198. Today's Tuesday, January 7, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Cybulski Correctional Center. Can you please state your full name and inmate number for the record?
Quinton Neal, 300198.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this afternoon is Attorney Dean and Parole Officer Richardson. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean from the Public Defender's Office on behalf of Mr. Neal. Good morning, sir. How are you?
All right.
Thank you. And Officer Richardson, can you please identify yourself for the record?
Yep. Parole Officer Richardson of the Mental Health Unit.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violates a conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Neal and Officer Richardson, can you please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes, I do.
Yes.
We're going to go over the procedure for the hearing. You're all set. You can put your hand down. Thank you. So first I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have important rights for this hearing, and I'm going to review them with you. The first is you have the right to an attorney and representation, and counsel's here present for you. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
Perfect. So you have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Officer is bringing against you any information underlying each charge. So Officer Richardson, can you please read the charge number 1, condition of halfway house, and the violation details?
On January 26, 2024, you were placed at the Aileen O'Connor Halfway House in Hartford. You signed a halfway house agreement acknowledging the rules of the halfway house. On 4/16/24, you were found by halfway house staff to be smoking cigarettes in a bathroom during house count. This is a violation of the written rules of the halfway house. Specifically, I may not use tobacco products within the halfway house. I may only smoke in designated areas at designated times. On 4/16/24, you were found by halfway house staff to have marijuana hidden on your person. This is a violation of the written rules of the halfway house. Specifically, I will not consume or possess marijuana in the halfway house. On 4/21/24, you refused to take your insulin that was prescribed to you. This is a violation of the written rules of the halfway house. Specifically, I will take all prescribed medications as directed. On 4/29/24, you urinated all over the floor in your bedroom at the halfway house. This is a violation of the written rules of the halfway house, specifically personal hygiene and cleanliness. On 5/6/24, you were found by halfway house staff to be smoking cigarettes in your bedroom. This is a violation of the written rules of the halfway house. Specifically, I may not use tobacco products within the halfway house. I may only smoke in designated areas at designated times. On 5/7/24, it was reported that it was reported by your treatment provider that you did not attend your appointments on 4/16/24 and 4/17/24, despite signing out of the house on a pass for those appointments. Your whereabouts in the community were entirely unknown during those times. This is a violation of the written rules of the halfway house. Specifically, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. I will only go to locations indicated on an approved community pass unless changes have been authorized by staff. On 5/9/24, you were found by halfway house staff to be smoking cigarettes in a bathroom at the halfway house. This is a violation of the written rules of the halfway house. Specifically, I may not use tobacco products within the halfway house. I may only smoke in designated areas at designated times. On 6/21/24, you were found by halfway house staff to be smoking marijuana on the grounds of the halfway house during a smoke break. This is a violation of the written rules of the halfway house. Specifically, I will not consume or possess marijuana in the halfway house. On 8/22/24, you were found to be smoking cigarettes in a bathroom at the halfway house. This is a violation of the written rules of the halfway house. Specifically, I may not use tobacco products within the halfway house. I may only smoke in designated areas at designated times. On 8/25/24, on 2 separate occasions, you were found to be smoking cigarettes in a bathroom at the halfway house. This is a violation of the written rules of the halfway house. Specifically, I may not use tobacco products within the halfway house. I may only smoke in designated areas at designated times. On 9/6/24, you soiled yourself during a medical incident. You were instructed by halfway house staff to change and wash your clothing. You refused to follow the instruction of staff and remained in your soiled clothing. This is a violation of the written rules of the halfway house, specifically personal hygiene and cleanliness. On 9/7/24, you were again instructed by halfway house staff to shower and change and wash your soiled clothing from the previous day's medical incident. You refused to do so. You did not comply with staff's instructions to shower and change and wash your soiled clothing until 9/10/24. This is a violation of the written rules of the halfway house, specifically personal hygiene and cleanliness. On 9/7/24, cups full of urine, spoiled food, and empty soda cans were found by halfway house staff on the side of your bed. This is a violation of the written rules of the halfway house, specifically personal hygiene and cleanliness. On 9/7/24, you were instructed by staff at the halfway house to clean your room. You responded by calling the staff a fucking faggot, a dirty cunt, and said, "Fuck you, I am not a fucking kid." This is a violation of the written rules of the halfway house. Specifically, I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On 10/17/24, you were found to be smoking cigarettes in a bathroom at the halfway house. This is a violation of the written rules of the halfway house. Specifically, I may not use tobacco products within the halfway house. I may only smoke in designated areas at designated times. On 12/5/24, you were found to be smoking marijuana at the halfway house. You were instructed by staff to stop and instead continued to smoke and blew the marijuana smoke into the staff's face. This is a violation of the written rules of the halfway house. Specifically, I will not possess or consume marijuana in the halfway house, and I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On 12/19/24, you reported to staff at the halfway house, if you get into trouble, you are, quote, going to attack him, end quote, referencing another resident that you believe to have reported on you to staff. On 12/20/24, based on your ongoing pattern of disruptive behavior and that your actions posed a significant safety risk to the facility and its clients, the program director of Aileen O'Connor requested your immediate removal and unsuccessful discharge from the halfway house.
Thank you. And for charge number 2, mental health treatment.
On 9/3/24, it was reported by staff at Wheeler Clinic, your mental health treatment provider, that you were not compliant with a psychiatric evaluation as stipulated by your mental health treatment condition.
Thank you. And then in addition, you've submitted evidence. Can you please identify the evidence you've marked submitted, please?
Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, signed halfway house agreement. Exhibit F, Aileen O'Connor resident handbook. Exhibit G, community solutions incident reports. Exhibit H, incident summary. Exhibit I, community solutions disciplinary action reports. Exhibit J, signed offender misconducts. Exhibit K, community solutions remand report. Exhibit L, Aileen O'Connor unsuccessful discharge summary. And Exhibit M, Board of Pardons and Parole decision information summary.
Thank you. Attorney Dean, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
I have not received any exhibits from you. Is that correct?
Correct. Thank you.
Do you need any additional time submitting?
Not at this point, thank you.
So today we do not have any witnesses, so it is the state's opportunity to make a short statement calling witnesses and testify with respect to probable cause and the severity of the allegations. Officer Richardson, do you have any additional comments to make?
The only additional comment is just that we want it noted, and as it is noted in the parole violation report, that Mr. Neal was given ample time and opportunity to comply with the halfway house rules. This included verbal warnings. It included extra housework at the halfway house. This included pass restrictions, and it also included cognitive behavioral therapy programming to address the disruptive behavior. However, despite that, from April, his time on special parole through December, so approximately 8 months, there was just a pattern of noncompliance with his parole conditions, specifically the halfway house placement.
And Attorney Dean, it is now your opportunity to respond and make a short statement, calling witnesses and testify with respect to probable cause.
Yes, thank you very much. As to the first charge, halfway house placement, I would just note that the halfway house agreement at Exhibit E was actually signed back in January of 2024, which predates my client's most recent placement on special parole supervision. I believe that occurred on 4/5/24. I would also argue Exhibit F should not be considered as it was not signed by staff or my client, and there's no evidence that has been submitted to show that my client did ever receive that handbook. As to the second charge, mental health treatment, I would argue that no finding should be made. Exhibit A, which is the parole conditions, does not specifically indicate where my client needed to engage in treatment, the specific agency, the specific location. It also doesn't indicate what the mental health treatment is for or what type of mental health treatment. So I would argue for that the evidence submitted is not strong enough. It hasn't met the burden of probable cause to establish that my client received that information and knowingly refused to participate in treatment. My understanding is that the elements for the mental health treatment charge are that he was made aware of the time, date, and place that he was to participate in treatment and then willfully did not do so. But my argument is that that first portion, that he was given a specific date and time to participate in treatment, there has been evidence submitted as to that. And that is it for my comments. Thank you very much.
Thank you.
May I speak to the evidence of the halfway house agreement?
Yes.
Being signed. So the halfway house agreement was signed on 1/26/24. So Mr. Neal was released on community release supervision status from Osborn to Aileen O'Connor on 1/26/24. He remained at Aileen O'Connor when his special parole took into effect on, excuse me, I have the date right here for you, on 4/5/24. So while there was a change in release, there was no change in his residence there. So it was not from a previous stay. It was from the change in supervision status, but that doesn't change the fact that he had been there, was well aware of the rules.
Nothing further from defense. Thank you.
So I'm just gonna take a moment and I'll let you know my findings. Okay, so for charge number 1, condition of halfway house placement, I am making a finding of probable cause based on state's exhibit A, D, E, F, G, H, I, J, K, and L. And for charge number 2, condition of mental health treatment, I'm also making a finding of probable cause based on states exhibits A, D, and J. I'm also finding that the acts are serious enough to warrant revocation, and I've determined that you should stay detained while you wait for your revocation hearing. So the records office at the facility, as well as your parole officer, is being notified now. And at your revocation hearing, Mr. Neal, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and if any sanctions should be imposed. Do you have any questions right now, Mr. Neal?
No, I don't even understand what's going on.
So, sir, I will be representing you for the parole revocation hearing. Today was all about determining whether or not there was probable cause for these violations. The hearing examiner did find probable cause on both of them, so we'll be going at a later date to the revocation hearing. I will set up a legal call with you prior to that date so that we can discuss the difference in standard for that hearing and also any potential defenses, okay?
All right.
Officer Richardson, would you like to be present for the revocation?
Sure.
Okay, so this does conclude the preliminary hearing and we're going off the record. Mr. Neal, you're all set for today.
All right.
Thank you. I'll be reaching out to you soon, Mr. Neal, okay?
Yeah.
Thank you. Thank you, Officer Richardson.
Thank you. Have a good day.
You too. Hi, Officer Munroe.
Hello. Oh, hello.
Perfect.
How are ya?
Hello. Thank you for joining us. Hopefully
Of course.
they answered. Kristen,
Yes.
what do you think about this one?
Bridgeport's video room is at the end of a long hallway, so an officer doesn't always hear the ring. But I can call them if you like.
I don't think they're gonna answer on this try. I believe it. And then we'll chat, okay? Thank you. Hi, how are you?
He's coming down right now.
Okay, great. Thank you.
No problem.
Lock the door.
This one in the box. You can cut it apart for me.
39 block, 39 block, send it on your RMP, please.
You cut it down the front.
Copy that, copy that.
What happened? What it done? It's at the far right here. Just real quick. Thank you.
Yeah. I don't know how long it's gonna be.
Good afternoon, Mr. Chase. How are you?
Good afternoon.
All right, we're going to get started. So I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Rodney Chase, inmate number 390667. Today's Tuesday, January 7, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Bridgeport Correctional Center. Can you please state your full name and DOC inmate number for the record?
Rodney Chase, 390667.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this afternoon is Attorney Dean and Parole Officer Munroe. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean from the Public Defender's Office on behalf of my client, Mr. Chase. Good morning, sir.
Martin.
And Officer Munroe, can you please identify yourself for the record?
Hi, Danielle Munroe, Parole Officer.
Thanks. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Chase and Officer Munroe, can you please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
I do.
So we're going to go over the procedure for the hearing. So first, I'm going to read you your rights. Then we'll review the parole violation charges that the state, your parole officer, is bringing against you. I'll then review and identify the exhibits filed for the record. The state will then have the opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you'll have the same opportunity. At the conclusion of this hearing, I'll inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, so sorry. So I was still fuzzy from Lyme disease. I've been getting my meds. They gave it to me for a week. I'm sorry. I'm still a little out of it, but yes, I understand.
Okay, so we're going to go over your rights for this hearing. So the first right is you have the right to an attorney and counsel is present for you. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. You also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Can you repeat that?
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case, and you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand those rights?
Yes, ma'am.
And are you ready to move forward?
Yes.
So we're going to review the charges that the state, your parole officer, has brought against you and the underlying information for each charge. So Officer Munroe, can you please read under charge number 1, condition of obedience to the law, the violation details?
Sure. On 12/6/2024, Department of Energy and Environmental Protection Division of State Environmental Conservation Police, ENCON, executed a search warrant to your brother's house, which he lives with his wife and 2 minor children. Your residence is also located on the property that your brother owns. During the cursory search of your brother's residence, officers observed 19 cannabis plants in various growth stages and several mason-type clear jars containing cannabis products were left unsecured. You admitted to officers that some of the cannabis plants were yours. In addition, the residence had several unsecured firearms in plain view. Although the firearms were registered to your brother, you admitted to the officers with the firearms being unsecured, you did have access to them when you were inside the residence. Due to these criminal acts you committed and the 2 minor children living at the residence, you were subsequently arrested for a criminal possession of a firearm, illegal possession of controlled substance, and 2 counts of risk of injury to a child.
Thank you. And can you also read the evidence that you have submitted for the record, please?
Sure. Exhibit A is the parole violation report. Exhibit B is a parole violation notice. Exhibit C is a parolee rights. Exhibit D is a remand to custody. Exhibit E is conditions of parole. Exhibit F is the Department of Energy and Environmental Protection Division of State Environmental Conservation Police ENCON Police Report, case number 240002570.
Thank you. Attorney Dean, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
I have not received any evidence from you, is that correct?
That's accurate, yes.
Do you need any time to submit additional?
We do not, thank you.
Okay, so at this time, the state will have an opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. Officer Munroe, would you like to make any statements?
No, I mean, the only statement I have is that his case is still pending through at least his next court date is the end of January. So I would just, the only thing I would say or recommend is just that he, at least stays in until his criminal case is disposed of. This is his first violation, as I mentioned in the his PVR.
Thank you. And Attorney Dean, would you like to make a statement?
Yes, I would. As to the charges, I understand this is a criminal violation. That's the only charge. There's a pending case in court, but there are just a couple of things I want to note for the record on behalf of the client. First, I just want to note that my client reports he was the one who informed his parole officer about this situation. He indicates to me that he did so immediately in the interest of being forthcoming and being compliant with his parole conditions. He did inform her. Second, I think it's important to clarify that my client, it is included there, but I just want to state again, my client does not reside in the residence that was the subject of this alleged incident or this search warrant. My client does reside in a separate residence on the property with a separate entrance. The subject residence in this case is a relative's home. Additionally, from speaking with my client and some other individuals who witnessed the situation, I believe there may be some evidentiary issues going forward. Specifically, we do not believe my client at any point took ownership of any of these items. And I would also just state from the report, it is somewhat unclear how my client was charged with some of these things. Nevertheless, I'm fully aware this isn't the proper venue to litigate those issues. That will take place in the Superior Court GA5 Derby, where the matter is pending. My client's looking forward to working with counsel there to resolve the situation as soon as possible so he can continue doing all of the positive things that he was previously doing while on parole. I also think it's worth mentioning my client has been on parole since 2022. He began discretionary, I believe, February 7th, 2022, and then was placed on special parole beginning 3/16/23. My understanding is that in that time, there has not been not so much as a single technical violation. There's been no sanctions, no interventions issued. He has been, I believe, fully compliant with his conditions. My understanding is that he's been working during this time, holding down a number of jobs, and I believe he's been meticulous in trying to abide by all of his parole conditions to the fullest extent possible. Unfortunately, this situation has resulted in the loss of jobs that he had achieved in the community, in addition to a number of resources that he had built for himself. He is really hoping to try and get released as soon as possible to resolve this matter while in the community. I would argue this isn't serious enough on its own to hold him or warrant revocation, and I would argue that he should be permitted to re-enter the community while on supervision and while awaiting revocation if that is warranted here. Thank you very much.
Thank you. Just going to take a moment and I'll let you know my findings. So I am going to make a finding of probable cause to charge number 1. condition of obedience to the law based on states exhibit A, E, and F. So, and I also am going to find that the act is serious enough to warrant revocation, and I've also determined that you should be detained while you wait for the revocation hearing. So the records office at the facility and your parole officer is being informed now, but they will be informed of this information. And your revocation hearing will be scheduled upon the disposition of your pending criminal charges. Okay?
So, Mr. Chase, that's what I was describing to you, how I will keep an eye on the court case. And as soon as I see that that's been resolved, I will ask for an addendum to be submitted so we could try and, get the process jump started for your revocation hearing, okay?
Yes, thank you.
No problem. I'll set up a follow-up legal call with you in case you have any questions. Sorry.
I've been having issues with everything. I've been in SEG for 30 days. I didn't have electricity for the first couple of weeks or lights. I didn't have my medication. I barely get out for rec. They skip me for rec a lot. So I'm trying to get somewhere. I've been on transfer detention waiting to be moved. So legal calls, the counselor never gets back to me. I've written him several times. The only time I've gotten a legal call was the first day, a couple days I was here, and just the other day with Hannah. And I can't put anybody on my phone. I tried adding attorneys and stuff to my phone, and it won't let me add them, saying they're not eligible. So I have no access to talk to anybody really, except for my brother and his wife.
I will email the facility today and ask for them to go ahead and set something up so that you and I can speak within the next week or so. And I'll also keep an eye on in case you are moved to a different facility, so that way I know where you're at, okay?
Thank you.
Officer Munroe, you were going to say something?
Yeah, I just didn't know, Rodney, because I was in touch with your sister-in-law. So whenever you do get released, pending the disposition of your criminal case, do you have a place to go, or would you need a halfway house?
If you can put it for a halfway, but I do have a couple of options. My girlfriend was trying to call you to see, and then also I'm trying to work on getting my paycheck from the auto shop so I can set up an apartment, possibly down in Seymour, either Derby Manor or around there by the Stop Shop, the high rise there. I'm trying to figure out something.
All right, I'll touch base with your sister-in-law.
All right, thank you.
Thank you, Mr. Chase. I'll set up a call with you soon.
All right, thank you.
All right, thank you.
Preliminary hearing for Russ Chase, and I'm going off the record. All right, you're all set, Mr. Chase. Take care.
All right, thank you.
Thanks. Bye, guys.
Thanks very much.
Bye. Thank you.
All right, guys. So it looks like this is it. This is good. That was the last hearing right there. I really appreciate you guys tuning in. If you haven't done so, if you guys could go ahead and hit that thumbs up or thumbs down or whatever you want to do. Anyhow, this is you have a collect call from, and I am collect call James. And like I said around here, life's like a candle. Once you blow it out, it's lights out. And with that, we are out. I thought we had another 3 hours, but it looks like they cut it short. All right, then. You guys have a good one. I'm out. Deuces.